bright that is like blinding. So we're gonna try to finish this. I don't know how the image is looking. So I can't even see it. Then my phone is about to die. Well, unalive itself. Oh, hold on. I didn't even do my intro. What it is, you guys, it is Yo Girl Cadillac. I am Cadillac Dixon. I'm the Drama Life Prison Wife. I'm the legally blind artist that is rapping and painting for justice, hoping to see justice before all face too bleak. It's your girl Cadillac. Anyways, like I said, my phone is about to unalive itself. So, I don't know how this gonna work, but we gonna try to go in for session 2 of reading this House Bill 183. I just got from Vizzo, basically visited my husband. As you know, I am the OG prison wife. I have been a prison wife for the last 23 plus years. It just made exactly 23 years on the 10th of April that my husband has been wrongfully incarcerated, but I was actually fighting and was a prison wife and trying to get him home since before, like before trial. So that's why I say 23 plus years, right? Um, my husband is wrongfully incarcerated, but I can't get no movement on my project. I have something called Project Reach the World, where I use all my art forms. I combine them together to try to tell his story of being wrongfully incarcerated with hopes that the story would gain traction and others would join in with helping me, because you can't get justice for somebody on your own. You just can't do it. You can't get justice for yourself. You won't get justice for your loved one. You won't get justice for nobody when you're doing it on your own. Um, and over these last 2 decades, I have tried everything I could think of to gain attention to this story, and I cannot. So it's looking like he's gonna have to do that time, that wrongful time. So right now, as it is in Florida, he would have to do 85% of his wrongful conviction. I'm going to tell you that it's wrongful. I'm going to keep telling you that because he shouldn't even be in prison. But since they are going to squeeze blood from a turnip and they're going to get this time out of him, we would rather it go down to 72% than 85, because at 72, we can get back to our lives a little bit faster than the 85%. I don't want to hold my breath. Like I say, hold your breath for justice. I don't even want set in stone. But per Marcello and some other people, they're saying it is passed. I don't know for sure, but we're going to read the bill. Okay. So where we left off, if you want to see the part 1 of reading Florida House Bill 183, I did before I had to go into my shift yesterday. I'll put that in the description below. This is part 2. I'm going to read until my phone unalives itself, which I don't know how long that will be, but maybe I could finish it. I'm going to plead the blood of Jesus over this live. So whatever happens, happens. All right, guys. So where we left off. Okay, behavior time not yet vested may be forfeited according to law after due process. Now this is page 10. For purpose of this subsection, good behavior time is deemed vested 2 years after being granted. Good behavior time under this section shall be computed on and applied to all sentences imposed for offenses committed on or after July 1st, 1978, and before January 1st, 1994. All outstanding deed, gain time, good behavior time, and rehabilitation credits are granted according to this section. All additional gain time previously awarded under former subsections 2 and 3, and all forfeitures ordered before the effective date of the act that created this section shall remain in effect and be applied in establishing an initial tentative release date. The department shall adopt rules to implement the granting, forfeiture, restoration, and deletion of outstanding deed gain time, good behavior time, and rehabilitation credits. Section 3, paragraph F of subsection 2 of section 316.027 Florida statute is amended to read: crash involve DEATH or personal injuries for purposes of sentencing under Chapter 921 and determining rehabilitation credits. Eligibility under Chapter 944, an offense listed in this subsection is ranked one level above the ranking specified in S 921.0022 or 921.0023 for the offense committed, if the victim of the offense was a vulnerable road user. Section 4, subsection 6 of section 316.1935 Florida statute is amended to read: 316.1935 fleeing or attempting to elude a law enforcement officer, aggravated fleeing or eluding, notwithstanding 948.01, no court may suspend, defer, or withhold adjudication of guilt or imposition of sentence for any violation of this section. A person convicted and sentenced to a mandatory minimum term of incarceration under paragraph 3B or paragraph 4B is not eligible for gain time under See, I don't know if that excludes Marcello because he did have a mandatory minimum, but his mandatory minimum was 10 years, and he's been way past 10 years a long time ago. So how does this... That's what I was trying to explain to Marcello. There's a lot of stuff in here, and it's hard to know who this even alleviates. Who even could qualify for this? Okay. Mandatory minimum term of incarceration under paragraph 3 or 3B or paragraph 4B is not eligible for gain time or credits under 944.275 or any form of discretionary early release other than pardon or executive clemency or conditional medical release under under S 947.149 before serving the mandatory minimum sentence. So he's been served. My husband's been served his mandatory minimum, which was 10 years. Okay, subsection 5, paragraph H of subsection 2 of section 381.004 Florida statute is amended to read: 381.004 HIV testing, human immunodeficiency virus testing, informed consent, result, counseling, confidentiality. Paragraph A does not apply. When testing for sexually transmitted transmissible diseases is required by state or federal law or by rule, including following situations: HIV testing pursuant to S796.08 of persons convicted of, can I even say that on YouTube? Let's say hostitution, or of procuring another to commit hostitution. HIV testing of inmates pursuant to 945.355 before their release from prison by reason of parole, accumulation of gain time or other credits, or expiration of sentence. Testing for HIV by the medical examiner in accordance with 406.11, HIV testing of pregnant women pursuant of 384.31, to those exceptions provided for blood, plasma, organ, skin, semen, or other human tissue pursuant to 381.0041. For the performance of an HIV related test by licensed medical personnel in bona fide medical emergencies, if the test results are necessary for medical diagnostic purposes to provide appropriate emergency care or treatment to the person being tested, and the patient is unable to consent, as supported by the documentation in the medical report, notification of test results in accordance with the paragraph C is required. For the performance of an HIV related test by licensed medical personnel for medical diagnosis of acute illness, where, in the opinion of the attending physician, providing notification would be detrimental to the patient, as supported by documentation in the medical record, and the test results are necessary for medical diagnostic purposes to provide appropriate care or treatment to the person being tested. Notification of I forgot it has to. Y'all, this is too much. Sorry. I forgot that my phone is about to unalive itself. Gotta start up the car. If HIV testing is performed as part of an autopsy for which consent was obtained pursuant to 872.04, for the performance of HIV test upon a defendant pursuant to the victim's request in a prosecution for any type of sexual battery where a blood sample is taken from the defendant voluntarily pursuant to the court order for any purpose, or pursuant to S775.0877, S915.27, or S960.003. However, the results of an HIV test performed shall be disclosed solely to the victim and the defendant, except as provided in SS 775.0877 and 951.27 and 960.003. If an HIV test is mandated by court order for epidemiological research pursuant to 381.0031, for research consistent with institutional review boards created by 45 CFR Part 46, or for the performance of an HIV related test for the purposes of research if the testing is performed in a manner by which the identity of the test subject is not known and may not be retrieved by the researcher, if human tissue is collected lawfully without the consent of the donor for corneal removal as authorized by 765.5185 or enucleation of the eyes as authorized by 765.519 for the performance of HIV test upon an individual who comes into contact with medical personnel in such a way that a significant exposure has occurred during the course of employment of course of employment within the scope of practice or during the course of providing emergency medical assistance to the individual. The term medical personnel includes a licensed or certified healthcare professional, an employee of a healthcare professional, or healthcare facility, employees of a laboratory licensed under Chapter 483, personnel of blood bank or plasma center, a medical student or other student who is receiving training as a healthcare professional at a healthcare facility, a paramedic or emergency medical technician certified by the department to perform life support procedures under 401.23. The occurrence of the significant exposure shall be documented by medical personnel under the supervision of a licensed physician and recorded only in the personnel record of the medical personnel. Cost of an HIV test shall be borne by the medical personnel or the employer of the medical personnel. However, cost of testing or treatment not directly related to the initial HIV test or cost of subsequent testing or treatment may not be borne by the medical personnel or the employer of the medical personnel. In order to use the provisions of this subparagraph, the medical personnel must be tested for HIV pursuant to this section or provide the results of HIV testing taken within 6 months before the significant exposure if such results are negative. A person who receives the results of a HIV test pursuant to this subparagraph shall maintain the confidentiality of the information received and of the persons tested. Such confidential information is exempt from 119.071 if the source of the exposure is not available and will not voluntarily present himself or herself to the health facility to be tested for HIV. The medical personnel or the employer of such person acting on behalf of the employee may seek a court order directing the source of the exposure to submit to HIV testing, a sworn statement by the physician licensed under Chapter 458 or Chapter 459 that a significant exposure has occurred and that in the physician's medical judgment, testing is medically necessary to determine the course of treatment constitutes probable cause for the issuance of an order by the court. The results of the test shall be released to the source of the exposure and to the person who experienced the exposure. For the performance of an HIV test upon the individual who comes in contact with non-medical personnel in such a way that a significant exposure has occurred while the non-medical personnel provides emergency medical assistance during a medical emergency for the purposes of this subparagraph. A medical emergency means an emergency medical condition outside of a hospital or healthcare facility that provides physician care. I don't understand what this has to do with the 2%. This is a lot. The test may be performed only during the course of treatment for a medical emergency. The occurrence of a significant exposure shall be documented by medical personnel under the supervision of a licensed physician and recorded in the medical record of the non-medical personnel. Costs of any HIV test shall be borne by the non-medical personnel or the employer of the non-medical personnel. However, costs of testing or treatment not directly related to the initial HIV test or costs of subsequent testing or treatment may not be borne by the non-medical personnel or the employer of the non-medical personnel. In order to use the provisions of this subparagraph, the non-medical personnel shall be tested for HIV pursuant to this section or shall provide the results of an HIV test taken within 6 months before the significant exposure if such test results are negative. A person who receives the results of a HIV test pursuant to this subparagraph shall maintain the confidentiality of the information received and of the persons tested. Such confidential information is exempt from 119.07. If the source of the exposure is not available and will not voluntarily present himself or herself to the health facility to be tested for HIV, the non-medical personnel or employer of the non-medical personnel acting on behalf of the employee may seek a court order directing the source of the exposure to submit to HIV testing. A sworn statement by a physician licensed under Chapter 458 or Chapter 459 that a significant exposure has occurred and that in the physician's medical judgment, testing is medically necessary to determine the course of treatment constitutes probable cause for the issuance of an order by the court. The result of the test shall be released to the source of the exposure and to the person who experienced the exposure. 412, for the performance of an HIV test by the medical examiner or attending physician upon an individual who expired or could not be resuscitated while receiving emergency medical assistance or care, and who is the source of the significant exposure to the medical or non-medical personnel providing such assistance or care. HIV testing may be conducted only after appropriate medical personnel under the supervision of a licensed physician documents in the medical record of the medical personnel or non-medical personnel that there has been a significant exposure and that in accordance with the written protocols based on National Center for Disease Control, Prevention, and guidelines on HIV post-exposure prophylaxis, and in the physician's medical judgment, the information is medically necessary and determines the course of treatment for the medical personnel or non-medical personnel. Costs of HIV tests performed under this subparagraph may not be charged to the deceased or the family of the deceased person. For this subparagraph, to be applicable, the medical personnel or non-medical personnel must be tested for HIV under this section, or must provide the results of an HIV test taken within 6 months before the significant exposure, if such test results are negative. A person who receives the results of an HIV test pursuant to this subparagraph shall comply with paragraph E. 13. For the performance of an HIV-related test medically indicated by licensed medical personnel for medical diagnosis of a hospitalized infant as necessary to provide appropriate care and treatment of the infant if, after a reasonable attempt, a parent cannot be contacted to provide consent. The medical records of the infant must reflect the reason consent of the parent was not initially obtained. Test results shall be provided to the parent when the parent is located. For the performance of HIV testing conducted to monitor the clinical progress of the patient previously diagnosed to be HIV positive. For the performance of repeated HIV testing conducted to monitor possible conversion from a significant exposure. Section 6, paragraph K of subsection 4 of section 775.084 Florida statutes is amended to read 775.084 violent career criminals, habitual felony offenders, and habitual violent felony offenders, 3-time violent felony offenders, definitions, procedures, enhanced, penalties, or mandatory minimum prison terms. 4. K. A defendant sentenced under this section as a habitual felony offender, a habitual violent felony offender, or a violent career criminal is eligible for rehabilitation credits granted by the Department of Correction as provided in 944.275 for an offense committed on or after October 1st, 1995. A defendant sentenced under this section as a violent career criminal is not eligible for any form of discretionary early release. I don't understand this. This is so conflicting. A defendant sentenced under this section as a habitual felony offender, habitual violent felony offender, or a violent career criminal is eligible for rehabilitation credits. For an offense committed on or after October 1st, a defendant sentenced under this section as a violent career criminal is not eligible for any form of discretionary early release or other than pardon or executive clemency or conditional medical release granted pursuant to 947.149. Well, Marcello is not a career criminal because he was wrongfully incarcerated on his first wrongful incarceration charges, so he has no other charges before or after. So he can't be a career criminal. Okay, 3, for an offense committed on or after July 1st, 1999. A defendant sentenced under this section as a 3-time violent felony offender shall be released only by expiration of sentence and shall not be eligible for parole, control release, or any form of early release. What is a 3-time? What does that mean? Is that where because felonies charges, they stack them. So is it if you have 3 felonies? This is confusing. That's why I told Marcello, it's almost like you need a lawyer to read this stuff to understand it. What is a 3-time felon? Does that mean you've been in prison 3 times? Like the 3 strikes you're out? Or what? I don't get it. Section 7, paragraph B of subsection 1 in subsection 2 of section 775.0845. Florida statutes are amended to read 775.0845, wearing masks while committing offenses. Reclassification: the felony or misdemeanor degree of any criminal offense other than a violation of 876.12 through 876.15 shall be reclassified to the next higher degree as provided in, and we're on page 20, we're just finishing 20, so 19, we're on 21, 19 more pages to go. Well, 20 more pages to go. This section, if while committing the offense, the offender was wearing a hood, mask, or other device that concealed his or her identity. In the case of a misdemeanor, the first degree, the offenses is reclassified to a felony of the third degree. In the cases of a misdemeanor of first degree, reclassified as felony to the third degree for purposes of sentencing under Chapter 921 and determining rehabilitation credits. Eligibility under Chapter 944, such offense is ranked in Level 2 of the offense severity ranking chart. In case, 2A, in the case of a felony of third degree, the offense is reclassified to a felony of second degree. In the case of felony of the second degree, the offense is reclassified to felony in the first degree. For purposes of sentencing under Chapter 921 and determining rehabilitation credit, eligibility under Chapter 944, a felony offense that is reclassified under this subsection is ranked one level above the ranking under former section, S 921.0012, former 921.003, 921.0022, or 921.0023 of the offense committed. Subsection 3 of section 775.0847 Florida statute is amended, and subsection 2 of that section is republished to read 775.0847, possession or promotion of certain images of child P. You can't even say that. Reclassification. A violation of S827.071, 847.0135, 847.0137, or 847.0138 shall be reclassified to the next higher degree as provided in the subsection. If the offender possesses 10 or more images of any form of child P, regardless of content, and the content, and B, the content of at least one image contains one or more of the following: a child who is younger than the age of 5, SADOMASOCHISTICABUSE involving a child, SEXUAL battery involving a child, SEXUAL BESTIALITY involving a child, any motion picture, film, video, or computer generated motion picture, film, or video including a child, regardless of length, regardless of whether the motion picture, film, video, or computer generated motion picture, film, or video contains sound. In the case of a felony of the third degree, the offense is reclassified to a felony of second degree. In the case of felony of second degree, the offense is reclassified to a felony of the first degree. For purposes of sentencing under Chapter 921 in determining rehabilitation credit eligibility under Chapters 944, a felony offense that is reclassified under this. So when they say they reclassifying the felony, does that mean that they're upping the felony from what you were originally like actually convicted of? They're upping the felony, and then off of the higher felony they're determining the 72%. Does that not just equal it back to the 85? This is very confusing. I need a lawyer. Shoot, I need a lawyer to help my husband get home. He is wrongfully incarcerated. This is when lawyers should be beating down my door. But we need some lawyers to break this bill down, because you can't just read this and understand it. And I'm quite brilliant, but it's still gray area, because it's just too it's overloading. It's way too much to understand who even qualifies for this. Okay. Section is ranked one level above the ranking under 921.0022 or 921.0023 of the offense committed. Section 9, Section 3 of Section 775.0861 Florida statute is amended to read 775.0861 offenses against persons on the grounds of religious institutions reclassification. 3A. In the case of a misdemeanor of the second degree, the offense is reclassified to a misdemeanor of first degree. In the case of a misdemeanor of first degree, the offense is reclassified to a felony of the third degree. For purposes of sentencing under Chapter 21, such offense is ranked in Level 2 of the offense severity ranking chart. In the case of felony of the third degree, the offense is reclassified to felony of the second degree. D, in the case of felony of the second degree, the offense is reclassified to felony of the first degree. E, in the case of felony in the first degree, the offense is reclassified to a life felony. For purposes of sentencing under Chapter 921 in determining rehabilitation credits, eligibility under Chapter 944, a felony offense that is reclassified under this subsection is ranked one level above the ranking under S 921.0022 or 921.0023 of the offense committed. We're on page 23 to 24. Section 10, subsection 3 of section 775.0862 Florida statute is amended to read 775.0862 SEX UAL offense against students by authority figures reclassification. 3A. In the case of felony of third degree, the offense is reclassified to a felony of second degree. B. In the case of felony of the second degree, the offense is reclassified to felony of the first degree. C. In the case of the felony in the first degree, the offense is reclassified to a life felony. For purposes of sentencing under Chapter 921 and determining rehabilitation credits, eligibility under Chapter 944, the felony offense that is reclassified under this subsection is ranked one level above the ranking under S9 under 921.0022 or 921.0023 of the offense committed. Section 11, subsection 1, and paragraph B of subsection 2 of section 775.087, Florida statutes are amended to read 775.087, possession or use of a weapon, aggravated battery, felony, reclassification, minimum sentence. 1. Unless otherwise provided by law, whenever a person is charged with a felony, except a felony in which the use of a weapon or a firearm is an essential element, and during the commission of such felony, the defendant carries, displays, uses, threatens to use, or attempts to use any weapon or firearm, or during the commission of such felony, the defendant commits an aggravated battery, the felony for which the person is charged shall be reclassified as follows. In the case of felony of first degree to a life felony, a case of felony of second degree to felony of first degree, in the case of felony of the third degree to felony of second degree. So this may affect Marcello there. They charged him with the weapon, though they recovered no weapon. There's no proof of weapon, but this is not for me right now to dispute the legitimacy of his conviction. His conviction is wrongful, but it's written in stone, right? So they have a weapon that they charged him with, though there is no weapon, never found a weapon, no evidence of weapon, no fingerprints, no nothing. Nobody hurt, nobody powed, no injuries, nothing that shows evidence that there was a weapon. They charged Marcello with a weapon, with a firearm. So he falls under felony with the firearm. So it looks like, if I'm not mistaken, whatever the felony was classified as, they're lifting it up a level, which seems like that's going to be more time. And then they are doing the 72%, which just seems like it's canceling itself out. That's why I told Marcello, I don't like getting my hopes up like this. What I wanted to do, just focus on the freaking release date you have. We have to get a decade down the road. When you go to wanting to get out any sooner than you know, like I even had to give up breaking the notion that his wrongful conviction story was going to break and he would be free. I have to wipe that off the slate because it's just not happening. So I have to look at his actual real life release date. So these bills come in, and if they make it to law, that gives hope that you would get out before your current release date, right? But when they give you the hope, but it's slowly being taken back, it's almost like when they give you more privilege. I have an example. I really can't say it though. It was on a job. We asked for something to be more in value. They gave us more in value, but when we got more, I I can actually relate it to that. Every time we ask for the increase of minimum wage and it goes up, everything else skyrockets, and your increase in pay does not really, you don't see it because everything else went up. So if they do this, if they reclassify everybody as a higher level and then apply the 72%, how are we doing any early release? So they're doing all this working for incentive to get out at the same time. That's why we need some people on this and actually posting about it. I can't find anything, and you can't just read this and understand it. You got to actually work with this stuff to know what it is. But eligibility under Chapter 944, a felony offense which is reclassified under this section, is ranked one level above the ranking under 921.00222 or 921.0023, a felony offense committed. Subparagraph A1, subparagraph A2, or subparagraph A3 does not prevent a court from imposing a longer sentence of incarceration as authorized by law in addition to the minimum mandatory sentence, or from imposing a sentence of DEATH pursuant to other applicable law. Subparagraph A1, subparagraph A2, or subparagraph A3 does not authorize a court to impose a lesser sentence than otherwise required by law. And is this pertaining to new people that will be newly sentenced? That's what I'm trying to figure out. Is this people that are already sentenced under these? Or is this when someone commits a crime after this goes into law? Okay, does not authorize a court to impose a lesser sentence than otherwise required by law, notwithstanding 948.01, adjudication of guilt or imposition. So it's about 15 more pages. Maybe I should stop it there. This is getting really... it's very extravagant. It's a lot going on in here. A lot in this bill to be law. And is it even passed? These are the questions I'm asked. Oh, I rhymed and I wasn't even trying. But I think we're going to stop there. And I'll do it in another section, another video. Because I don't want this to cut off on me, and I need to let the phone charge a little bit. And then me reading this is not easy. Y'all know I'm the legally blind artist, so, and that sun is in my eyes. The screen is glaring, so it's not the easiest to read this. So, but we only got 15 more pages to make it through. All right, guys, I'll talk to you later. It's your girl Cadillac.